Barber and Ms. Lich cannot be responsible for everybody else's action. And that's important to show that it was not just one group, one unity. Some people were doing their own things without the agreement or knowledge even of Mr. Barber.
You talked a lot about the mens rea today. Do you want to explain a little bit what that means and what you're attempting to demonstrate when it comes to Barber's intent?
Yeah, so the mens rea is the Latin word for the intention. And in some of the charges that he's facing, it is the intention has to be subjective, which means it's what was in his mind. And that's very important because if in his mind he was morally innocent and he was saying that he thought he was doing everything he could to be lawful, then he should not be convicted of anything.
For the actus reus to occur, you can't metaphorically be involved in an obstruct.
Once again, it just feels like it's an emotional appeal, an emotional argument, but you know, facts don't care about your feelings, I guess, as someone once said.
Sarah Stock for Rebel News. We're back for day 41 of the Tamara Lich trial. Tamara is undergoing mischief charges for her participation in the 2022 Freedom Convoy against vaccine mandates. This is actually the longest standing mischief trial in Canadian history. That's just how you know that the system is coming after Tamara with everything she has. In this case, the process really is the punishment. This trial's been going on for almost a year now, but I'm here to cover today's proceedings. Yesterday, the Crown finished their closing arguments, and today we are going to see the defense respond. So I'll make sure to keep you updated. So follow along with my Twitter if you want to find out what happens today.
Well, we also had to prepare a written submission, which were also very lengthy because there's a bit of, although it's a mischief trial, there's a bit of complexity in terms of the level of aiding, abetting, counseling, and then there's breach of a court order, counseling a breach of a court order. So there's different legal tests to be met. So there's a lot of preparation for that. But our position, and as argued by before the court, is that my client is innocent and was morally innocent and legally innocent of any crime.
We're now on lunch break, and the defense has spent all morning responding to the Crown's evidence by providing further context to many of the text messages that were shown. And this further context is actually demonstrating that not only were Lich and Barber not counseling others to commit mischief or committing mischief themselves, but the evidence is actually demonstrating that they were counseling others to not commit mischief. This was shown in many series of text messages, with Barber cooperating with police and encouraging others to do so as well. He was expressing frustration that others were not cooperating with police and were blocking roads. He even mentioned that he got others to unblock a road 3 times, and he was upset over the fact that they continued to block it. A lot of the evidence is also demonstrating that there were factions within the convoy that had competing interests, with some of them wanting the convoy to be unlawful and gridlock the city. But so far the evidence is showing that both Lich and Barber were unhappy with this, and they were trying to encourage others to keep the peace and keep the convoy lawful. Does it seem that the Crown's evidence is entirely reliable?
I can't comment on that. I'm going to I made some submissions on some of the evidence today. I'm going to continue to make submission, and I prefer not to go into that until I make my submissions before the court.
Well, court is over for today. Just a quick recap. Today we saw the defense presenting their closing arguments with Ms. Magus, who is the counsel for the co-accused Chris Barber, presenting her closing arguments. And a lot of the focus today was on the mens rea, the intent. The position was that Barber did not have any intentions to break any laws from the time before the convoy, during, and after he was arrested. The position was that he was not inciting any sort of mischief or committing any actual acts of mischief himself. What do you think? You were talking a lot about the different factions involved in the convoy. Why do you think that's relevant to bring up for the prosecution?
Because from our perspective, Mr. Barber and Ms. Lich cannot be responsible for everybody else's action. And that's important to show that it was not just one group, one unity. Some people were doing their own things without the agreement or knowledge even of Mr. Barber.
You talked a lot about the mens rea today. Do you want to explain a little bit what that means and what you're attempting to demonstrate when it comes to Barber's intent?
Yes, so the mens rea is the Latin word for the intention. And in some of the charges that he's facing, it is the intention as to be subjective, which means it's what was in his mind. And that's very important because if in his mind he was morally innocent and he was saying that he thought he was doing everything he could to be lawful, then he should not be convicted of anything.
So it seems like the defense's general position today was that not only was Barber not inciting others to commit mischief, but he was actually encouraging others and leading by example by staying in constant communication with the police and encouraging others not to commit mischief. He was telling them to keep the trucks rolling. He was telling them to comply with police. Do you want to talk a little bit about that?
Sure, yeah. Well, Diane Magus is an excellent defense attorney, and so she focused her argument on the mens rea of her client, because for most offenses you need to prove the mens rea, so the subjective intent of the client to commit the offense and the actual physical conduct of the defendant in committing the offense. So she focused on the mens rea of her client, and that's, to your point, she said, actually, my client wasn't committing mischief or intimidation or counseling, either of those things. He was trying to get the protesters to act peacefully, lawfully, to comply with the police instructions, to obey, and to have the trucks not block the lanes, and to go to the staging areas, go to this field outside Ottawa, to slow roll. She said my client wanted to slow roll, not to obstruct or congest the intersections. And she went through each text client received or sent to show that.
And that's what the police were telling them to do also. They were encouraging them to do a slow roll because they didn't want them entirely blocking the roads. It's not legal to do that. But the slow rolling is a legal form of protest. Is that correct?
That's right. That's what the contention was, that the police allowed this slow roll. And as Ms. Magus pointed out, that's generally what a protest involves. You're causing some grief to the citizens of the population, but you're not actually shutting things down. Yeah. So the slow roll, she contends, was legal, and that's what her client wanted the other protesters to engage in.
Yeah, and then it was also brought up that the Emergencies Act being enacted was not to enforce already existing and already being enforced bylaws such as parking violations. The Emergencies Act was supposed to escalate it to the federal level to be able to crack down on the actual protest itself, not on any mischief committed within the protest. Is that correct? Is that what I was getting?
Yeah, I mean, we don't know why the Emergencies Act was enacted at the provincial level, but the contention, I think, was the court heard evidence that it was because the province wanted to access the additional resources that come with that invocation of the Emergencies Act. So I think that was, as you say, they already had their bylaw enforcement powers to send out parking tickets or bylaw infraction tickets. They didn't need the Emergencies Act for that.
Yeah, and then another point that the defense kind of just slipped this in there because she said she wasn't sure, where to fit it in, but she was just calling into question, or it seemed like she was calling into question, the reliability of some of the Crown's evidence, some of their witness testimonies. She used in one example of a witness saying she saw people saw truckers defecating on church property from a window, and then later when she was questioned, so did you directly see it yourself? She said, well, no, but I heard someone saw it, but I saw them urinating.
Right, yeah, it was a strange moment, but I think Miss Magus she said she was irked that testimony was presented by the Crown's witness early in the trial, that there was some defecation or urination on church property. And so she circled back to that in her closing. She said, actually, that was a lie. She used those words, that was a lie. And she demonstrated that, in fact, there was no evidence of defecation. She saw some urination or something like that. But that was, I guess, she chose to come back to that point because it was kind of a gross moment, and it was just hung there by the Crown, and she wanted to address that. So, yeah, that was a tactical choice she made.
And my thought when this was brought up is maybe you understand more because you're a lawyer, but I'm listening to that and I'm thinking, why does that even matter if a single protester did defecate on a church property? What does that have to do with Chris Barber and Tamara Lich? There's no evidence of them telling anyone to defecate. There's no evidence they were doing it themselves. It just didn't make any sense to me.
Right. So, I mean, that's a good point. But I've said this before, people are story listeners and storytellers, and generally it's people's psychology is the best story wins. And the story the Crown laid out was that this was, at least they said initially, that this was a violent protest and there was some harassment going on, and then we heard about this weird moment of defecation and urination on church property, and that builds a psychological, a distasteful picture about the protesters. And we heard a lot of that wasn't actually the case. There wasn't much evidence or any evidence of violence, and now Ms. Megas called into question the evidence of this unpleasantness by the protesters. So I think it might have been tactically a good move.
Yeah, it kind of seems like it's just creating this emotional story. It's, but we're not focusing on the actual, legal facts of what happened. What can we actually convict anyone of? It's just kind of weaving together this story to make the protests look evil or whatever, but they had every single right to peacefully protest.
Yeah, that's right. And Ms. Meg is an excellent attorney, so she, at the end of her submissions, she mentioned that the Crown's argument was that the charge of obstruction arose because the Barber and Lich stood metaphorically shoulder to shoulder with the protesters. And it was such a strange phrase, at least to lawyers, to hear, because usually the obstruct charge arises when you physically resist or interfere with a peace officer in the execution of their duties. And the judge stopped. Ms. Megas said, well, is that really the Crown's argument? And I thought, no, that can't be the Crown's argument, because that's a strange argument to make. And sure enough, Ms. Megas took the court to the Crown's material, where the Crown said that the obstruct arose in part from the metaphorical standing shoulder to shoulder by the defendants standing shoulder to shoulder with the protesters, and Ms. Megas pointed out that that doesn't exist in law. You have to physically be present for the actus reus to occur. You can't metaphorically be involved in an obstruct.
Once again, it just feels like it's an emotional appeal, an emotional argument, but facts don't care about your feelings, I guess, as someone once said. Where do you see, it seems like the trial's going to be going on next week. Do you think it will actually wrap up by Friday, or? Well,
I've learned at day 40 of a trial that was supposed to go 7 days that you kind of have to anticipate that the lawyers are going to go overtime. So we have Monday and Tuesday reserved, and then Friday we're back, and I would suspect we're going to be back Friday. But Justice Perkins McVeigh was adamant that this is going to wrap up, so she controls her courtroom pretty well. So hopefully we'll be done Friday.
That's good, but definitely the process here has in fact been punishing Chris and Tamara, I would say.
Yeah, it's been a long time, and I think people are tired.
Well, that wraps up today. It seems like court is going to reconvene next week on Monday, Tuesday, and probably Friday. The judge seems to want to wrap this up soon, but who knows? It could go for even longer. It's already been 41 days. Once again, the process really is the punishment. They're coming after Lich and Barber with everything that they have. For Rebel News, I'm Sarah Stock. Because of the drawn-out nature of this trial, Tamara Lich's legal bills have added up to hundreds of thousands of dollars. She cannot pay these bills herself, but thankfully there's plenty of Canadians out there who want to help her in her fight for freedom and donate to support her legal fund. If you would like to do that, you can head over to helptamara.ca. Also, I've been here for a couple of days reporting on the trial. Tried to make it as cheap as possible, just some cheap Airbnbs and a few meals. But if you would like to support my work and my reporting here at Rebel News, please head over and donate at tamaratrial.com.